Missouri and the states win against the Biden administration, securing a victory to depose an FBI special agent. Missouri's Eric Schmitt is the person who has been leading the charge on this, and he posted on Twitter the following. He says, breaking, in our lawsuit against the Biden administration for colluding with social media companies. A lot of this was about Hunter Biden and the laptop, of course. All of it got censored and buried right in the months leading up to the election. A lot of people have problems with that. But Eric Schmitt has been suing the Bidens, wanting depositions from Fauci and Psaki and Murthy and others who are in the Biden White House colluding with the tech companies. He says, big news, the deposition of an FBI official is going to move forward after our big win in court. Let's take a look at who this person is. FBI Special Agent Elvis Chan is going to be the individual who is going to be deposed unless something changes. A little bit more about him. He is an assistant special agent in charge, FBI San Francisco Cyber Branch. You can see the details here. He manages the field office's cyber branch responsible for cyber investigations, digital forensics, technical operations, community engagement, public affairs, 18 years in the Bureau. He is been involved in a bunch of stuff, engineer, semiconductors, and all sorts of chemical engineering, went to Naval Postgraduate School, Homeland Security Studies, University of Washington, bachelor's degree, chemical engineering, and so on. Okay, this is the guy that they are talking about, and I was able to find a little bit about him. This is FBI Special Agent Chan, who is going to be deposed by Eric Schmitt, Missouri Attorney General, giving us some details about who he is and what he does.
Hello, everyone. My name is Elvis Chan. I'm the Assistant Special Agent in charge of the Cyber Branch here at FBI San Francisco. I manage 9 squads that are responsible for the cyber investigations in this office, the digital forensics, technical operations, private sector engagement, public community outreach, as well as public affairs.
What's the most
important skill? I think that the most important skill that people working in cybersecurity need today is adaptability. You're not always going to know what's going to happen. You're not even going to realize that you've been in a security incident until well after the fact. So I think having a cool head, being flexible, and being able to take things as they come is the most important skill that you
That's good advice. Yeah, that's good advice.
I would say that the most advanced social engineering attack I've seen, or the most sophisticated, is probably from the Twitter hack. It's been a year and a half now. So what they did is vishing, which is a combination of sending spearfish emails to the employees, but then following up with phone calls to convince them of who they were supposed to be. In this case, they were supposed to be fellow Twitter employees. So vishing has been a big deal.
Phishing. Don't give your passwords out. Okay, so that's the FBI special agent who is the subject of a deposition. Now, he works in San Francisco. He's this engineering cybersecurity person. We just heard him talk about Twitter. Oh, the Twitter hack, right? Oh, they just got hacked by all this stuff. So he obviously is somebody who interfaces a lot with these big tech companies. He's right there in, right outside of Silicon Valley, and he is working hard on these issues. Now, Missouri filed a lawsuit against the Biden administration, and there has been a lot of activity on this case because the judge has ruled that many people in the administration have to sit for depositions. Now, the government really does not want that to happen at all. We're going to take a look at the government's reply before we take a look at the judge's final ruling, which is ordering the deposition of Elvis Chan. And this is an interesting ruling from an interesting judge. Now, the way that this works, we're going to fast forward through a lot of the sort of back-end legal stuff. The original motion for a deposition is filed by the plaintiffs, the people who sue. In this case, it's Missouri. And the government was filing a response, or actually they filed a motion to stop him from having to testify, everybody. And they submitted a second request to sort of renew that. And then there was a response from Eric Schmitt, and then there's a reply. Okay, so you get the original filing, a response, and then a reply. We're going to skip the first two. We're just going to jump into the reply. We're going to give the government the last word before we take a look at the ruling, right? This is the final argument from the government before the judge ultimately rules. Government prosecutors submit how big is this thing? Let's see how big this is. I can't see it. Oh, government prosecutors submit a 6-page filing. This out of the Western District of Louisiana, state of Missouri versus Joe Biden. Prosecutors are replying in support of the defendant's motion for reconsideration. They're saying, Judge, look, I know you already said that this guy, Elvis Chan, he needs to be deposed. Okay, we know you already ruled on that. We're asking you to reconsider. Okay, please, like really please. Like we really do not want this guy to testify. Okay, don't let him testify. So they say, Judge, okay, let's catch you up. Judge, in the deposition order, which you said he needs to testify at, this court grounded authorization of the deposition on Elvis Chan based on statements that he allegedly made to Meta, okay, so Facebook, saying that the states are arguing that the FBI agent Chan's communications with Meta are fact, and they're saying, Judge, that's really the only reason you're allowing this deposition to take place. You're taking their word for it. We're asking you not to do that. They say, the recent letter from Meta's counsel clarifies that the states here, Missouri, the description of the relationship between those communications and, quote, the Hunter Biden laptop story was mistaken. Oh, so the states are saying, Judge, you should allow us to communicate with Elvis Chan. Why? Because our evidence shows that he had a close relationship with Meta. Government, these aren't prosecutors, but these are government civil rights defense attorneys, essentially. The government are responding saying that there is no need to interview Elvis Chan because Meta, their lawyers, told us that the relationship between their lawyers and Chan was different. The states say Chan and Facebook were colluding. Facebook is saying, no, we weren't. So the government is saying, in this situation, don't depose him because the plaintiffs are totally wrong. Don't listen to them. In opposing reconsideration, right, because the states want this deposition to happen, the states recite at length the events predating Meta's letter, which are unavailing, they say. But the key question here is what is known now, not what plaintiffs understood Meta to be saying before the letter. So they're saying, well, Meta may have said something previously, but they're saying this now, and so we should give them benefit now. They say the states additionally offer other new justifications to depose the FBI agent, which are founded on incomplete and incorrect accounts of 2 interviews of Mr. Chan. They also improperly attempt to lower the bar that they must clear by treating the deposition as part of ordinary discovery rather than extraordinary, saying that they're mistaken, there is no connection between Mr. Chan, and they should not depose him. Now, quickly, we can go through some of these arguments. They say that Mr. Chan, according to Meta, they sent a letter on October 25th. They said, at no point in time did Chan advise Meta, quote, to suppress the Hunter Biden laptop story, nor did any of his colleagues. Okay, that's the letter. Oh, no, Mr. Chan didn't tell us to do anything. Ooh. That statement is new evidence not previously available to the court. Its clear import now is that the record does not support the state's argument that he was colluding with Facebook. So in other words, Facebook said they weren't colluding, therefore they weren't colluding. They make the argument, they say that the states are also saying there's new misconduct that has popped up. They link to this opinion piece from the New York Post and another letter, a declaration from a Twitter executive in a federal election commission, looks like a declaration lawsuit or something. Neither source supplies a factual basis for the state's allegations about Chan and Meta. The opinion piece adds nothing new. Instead, it characterizes and opines on a document, but it's not accurate. After the New York Post published articles in October 2020 about a hard drive, the declaration says that Twitter's trust and safety team took action, which we all saw. We lived through this, right? They canceled the entire story. But nothing in that declaration contradicts Meta's letter that Mr. Chan at no point advised Meta, right? So they're saying, okay, all of that may have happened, but Chan specifically, the special agent, he wasn't the one responsible for it. So the government says, in short, there's really no basis for him to come and testify. Mr. Chan and Meta, none of it was collusion between the two of them. They're also pointing to 2 online interviews, and they're saying, these interviews don't justify Mr. Chan's deposition. And they're going through his record. And the government is basically explaining why this guy should not be deposed. And so you understand the point of this. They say, for the reasons stated above in the opening memorandum, the court should withdraw, in other words, reverse authorization of the deposition of Mr. Chan. Signed off on by special counsel, litigation counsel, principal deputy assistant. And we've got Iridan Sir, trial attorney for the U.S. Department of Justice out of the Civil Division in D.C. Okay, please, 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 the nuts and bolts of this, please, please, please don't interview the FBI special agent. He's not closely connected. He's not relevant. It doesn't matter, so on and so forth. Now, the judge took all of that into account and issued the following order. Federal judge issuing a memorandum order ordering the continued deposition of Mr. Elvis Chan. He, of course, is FBI assistant in charge, somebody who was allegedly colluding with the big tech companies, being sued by the state of Missouri versus the Biden administration. The judge orders says, for the reasons set forth below, the motion for reconsideration, the beg, please don't depose this guy, is hereby denied. Background. The judge writes as follows. Judge says, on May 5th, the states sued the Biden people, and on August 2nd, they filed an amended complaint. In the complaint, the states allege that Biden and all of those different executive level people colluded with or coerced social media companies to suppress disfavored speakers, viewpoints, and content by labeling the content disinfo, misinfo, and malinfo. The states allege that the suppression disfavored speakers, viewpoints, and content, they say it constitutes government action and it violates the First Amendment. They said that the scope of this inquiry, the scope of this censorship, suppressed speech that covered a bunch of issues. The Hunter Biden laptop story, the prior elections, COVID and lab leaks, masks, mail-in voting, censorship of various people like Dr. J. Bhattacharya, Dr. Aaron K., Barrington Declaration, censorship, Jim Hoff, Gateway Pundit. Okay, all of these people were suppressed. All of it. We covered most of it. Co-director of Freedom Louisiana, Reopen Louisiana on all these platforms. Got it. The court ordered that the plaintiffs, meaning the states, are authorized to take 8 depositions as part of the discovery process. On October 28th, the Biden administration filed a motion for reconsideration. They said, okay, look, we'll let you depose some of these other people, but not Elvis Chan, footnote 7, asking this court to reconsider the previous ruling that authorized it. The judge says, well, while there is no motion for reconsideration per se, there is a motion to alter or amend the judgment under the federal rules of procedure. So this judge is being a little bit picky here. Motion for reconsideration, he's saying, it's kind of not in the rules, but I'll just interpret your request according to a different rule. The Fifth Circuit has explained that a Rule 59 motion calls into question the correctness of a judgment, but is not the proper vehicle for rehashing evidence, legal theories, or arguments that could have been offered or were offered before the entry of judgment. Okay, so the judge is doing the old sort of Iraq format where the judge will tell you what the issue is. Okay, so they're saying this is the issue. Reconsider the previous ruling. That's the I. What's the rule? The rule is the law. The law says, 59E is really the only thing that governs what you're asking me to do. You're asking me to reverse myself. Well, how can I do that? What does the law say? All right, Federal Rules of Civil 59E says I can't go back and rehash old entries. Okay, that's the R. Let's do some analysis now. What's the argument? What's the analysis that we're going to do as we apply the rules to the issue? Okay. In its motion for reconsideration, the judge says, the federal defendants, Biden administration, ask this court to reconsider its previous ruling, authorizing the states to depose Chan. The sole basis for the motion for reconsideration is a recent letter from the attorneys representing Meta, Facebook. The letter stated that Meta did not identify Chan as the person from the FBI that conveyed communications between FBI and Meta that led to the suppression of the laptop story. Now, that statement, the judge says, is disputed by the states. They say that Meta didn't say that. They maintain that in a phone call on September 15th, Meta's counsel orally identified Chan as the FBI official who was directly involved in the Hunter Biden laptop related communications with Facebook. The court held in its ruling that plaintiffs are allowed to depose Chan. Why? One, because Chan had authority over cybersecurities for the FBI in San Francisco, in California, which includes headquarters of major social media platforms. So he's kind of closely connected there. Chan also played a critical role for the FBI in coordinating with social media platforms related to censorship on those platforms. And three, because Meta identified Chan as the FBI agent who communicated with Facebook. Meta's counsel identified Chan as the person who communicated with Facebook to suppress the Biden laptop story. So the judge continues and says, well, Chan's alleged involvement in the laptop communications issue was not the sole reason for his depo. Okay, there were other reasons. The court conducted its analysis on whether Chan should be deposed under the assumption that as an assistant special agent in charge of the FBI field office, Chan was a high-ranking official, even though there was scant evidence produced in support of such finding. The court finds that even if Chan were not the person identified by Meta to have conveyed the information to Facebook on the Hunter story, there still exists independent reasons for allowing Chan's deposition. He's like the senior officer there, the senior special agent in San Francisco. The judge says the issue of Chan's involvement in the Hunter laptop communication is an additional reason to allow the states to depose him. If Chan played no role in the suppression of the laptop story, then such information will be made very clear in his deposition, won't it? They'll say, Mr. Chan, were you the person who told Facebook to suspend Hunter Biden's story dissemination? He'll say, no idea who that was. And you'll say, well, you're in charge of the FBI. Shouldn't you figure that out? And he'll say, I'll look into it. And then he'll give him the actual response, and they can go and depose that person. Judge says Chan had authority over cybersecurity issues for the FBI in San Francisco, in California, and that includes the headquarters of major social media platforms, and it played a critical role for the FBI in coordinating with the social media platforms related to censorship. Even if Chan played no role in the Hunter story, he may have knowledge of who did, and his deposition is nonetheless warranted. Therefore, the Biden administration's motion for reconsideration is hereby denied. Conclusion: for the reasons set forth herein, it is ordered that the federal defendant's motion is denied. Signed by Judge Terry Doughty, Monroe, Louisiana, November 14th. Boom. So FBI special agent will be sitting down, and he's going to be asked specifically by Eric Schmitt, seen here from Missouri, what his role was, what his involvement was in covering up or encouraging the social media platforms to cover up the Hunter Biden story. Great news. A lot of fun on that. And so we'll see what happens as these depositions get scheduled. We'll continue to cover them. Thank you for liking this video wherever it is you're watching it, and for joining us on the next one.